Welcome back to the Bradcast. Brad Friedman from bradblog.com. On Wednesday, the nonpartisan good government group Free Speech for People filed an urgent motion before the federal district court in U.S. v. Stone on behalf of constitutional law professors Judge Sugarman, who we've had as a guest on this show in the past, and Ethan Lieb, seeking permission to submit an amicus or friend of the court brief arguing that the court should not automatically accept the executive grant of clemency issued late on a Friday night about a week ago for Donald Trump's longtime friend and former campaign official and longtime GOP dirty trickster going back to the Nixon days, Roger Stone. But rather, the group of attorneys argue, the judge should consider whether Trump's grant of clemency itself may, in fact, be unconstitutional. Really? Yes, really. Stone was convicted by a jury on 7 felony counts, including obstructing a congressional investigation by lying to Congress and witness intimidation. Yes, he actually threatened to kill a witness in this case and his dog. Stone was ultimately sentenced to 40 months or about 3 years in prison after Trump's newest personal fixer and U.S. Attorney General Bill Barr interceded in the case to undermine the DOJ's career prosecutors who had sought as many as 8 years for Stone, according to the mandated federal sentencing guidelines they followed in their submission to U.S. District Court Judge Amy Berman Jackson. Barr's men, the day after Trump complained in a tweet about it, told the judge that the original 8-year recommendation was excessive for the sentencing, and the career DOJ prosecutors who had worked for years to get the conviction in the case subsequently resigned in protest in response. And then Stone was ultimately given just 3 years in prison, which were supposed to begin this past Tuesday, before Donald Trump interceded and granted clemency on the late on the Friday night before. Stone's convictions stemmed from his repeated efforts to impede both Congress and Special Counsel Robert Mueller's investigation into Russia's alleged interference in the 2016 presidential elections, crimes that Stone now pretty much admits that he carried out in order to protect President Trump. As the sentencing judge Jackson explained in her closing remarks, Mr. Stone, quote, was prosecuted for covering up for the president. That cover-up was successfully completed, it seemed, when Trump exercised his considerable constitutional Article II presidential powers to commute Stone's sentence from 40 months to 0 months with a stroke of his pen. That was that. Except it isn't, according to the folks at Free Speech for People. This case isn't over, says Ron Fine, legal director at Free Speech for People, also a recent guest on this program, by the way. Fine says the Supreme Court has acknowledged that the pardon power is not unlimited, and the Constitution requires the president to exercise that power loyally and carefully in the public interest rather than in his own self-interest. But does Donald Trump ever do anything that is not in his own self-interest? And if that's what he did here, as seems 100% obvious to pretty much every sentient human being at this point, can it actually be prevented or overturned somehow at this point? The folks at Free Speech for People, citing Professors Sugarman and Lieb of Fordham Law School, in fact, think that it can be, and that argument should be allowed to be submitted to Judge Jackson for her consideration. In their motion filed on Wednesday, they write, amici, that is the friends of the court, seek to advise the court of issues that are not likely to be raised by either the United States or the defendant. In particular, amici seek to advise the court of reasons why the executive grant of clemency executed by President Donald John Trump with respect to the defendant in this matter is or may not be constitutionally valid. This position, they write, is adverse to that of the defendant, but the United States, in other words, the Justice Department, who was previously attempting to hold Stone accountable until they appear to have abdicated themselves from that role, The Justice Department will not adequately represent amicus' interest in presenting these issues because the Department of Justice will not question the validity of an executive grant of clemency issued by the president. Free Speech for People cites Sugarman and Lieb's argument that the Article 2 of the U.S. Constitution, which also grants the president his pardon powers, twice imposes a duty of, quote, faithful execution on the president, who must, quote, take care that the laws be faithfully executed, and take an oath or affirmation to, quote, faithfully execute the office of president. But here, the group seems to be arguing the president is doing no such thing. Joining us now to discuss what would be a remarkable turn of events among a series of already remarkable events is constitutional attorney Ben Clements. He is board chair and senior legal advisor at Free Speech for People and co-counsel on the motion that the group filed on Wednesday before Judge Jackson. Mr. Clements is a former federal prosecutor, former chief counsel to Massachusetts Governor Deval Patrick, and has been an attorney in the private and public sectors for more than 30 years with his expertise, including constitutional law. Welcome to the Bradcast, Ben Clements.
Thank you, Brad. Good to be with you.
Good to have you here. This would be a remarkable, if fascinating, turn of events in the Stone case. First question, Ben, why must you seek a motion to submit a friend of the court brief in this case? Isn't anyone welcome to do so?
Well, not as a matter of course, particularly in the trial courts. Amicus briefs are not all that common, and generally, it is expected that you would get permission from the court to file an amicus brief. But in this particular case, Judge Jackson actually issued an order stating earlier on that any party wishing to file an amicus brief in the case had to seek leave of court and have that granted before filing the brief. So the process that we have followed here of filing our motion and awaiting permission from the court before filing the brief is in accordance with the order of the judge.
I gotcha. And before we get to the substance here, as a number of folks have asked me about this since Trump's executive grant of clemency a week ago Friday, what is the difference between granting a pardon, which reportedly Roger Stone did not want, and clemency, which is what he was ultimately granted?
Well, the phrase clemency is actually a broader phrase that refers to any relief from a criminal judgment or sentence. And clemency includes both pardons, which is essentially relief from the conviction itself, and commutations. And a commutation is simply either a reduction in or in this case, an elimination of the sentence in its entirety. So they're both forms of executive clemency, but the difference is a pardon essentially relieves the defendant from the conviction in its entirety, whereas a commutation simply relieves the defendant of the burden of some or all of his sentence.
Gotcha. Now, does Judge Jackson have to in some way technically approve the president's issue of a commutation here? Isn't it already that power of clemency? Isn't that already absolute and a done deal at this point, whether she approves of it or not?
Well, you've got a couple questions in that question there, Brad. Let me try to separate them out.
Okay.
One is whether Judge Jackson needs to approve, and the answer to that is no. The president's power of exercising a pardon or a commutation is not dependent upon and does not call for permission from a judge. But, and this I'll get to more fulsomely in a minute, but it's not an absolute power. And so whereas in this case it is being misused and unconstitutionally abused, it's our position that the only way to enforce that constitutional provision is for the judge to step in and declare it unconstitutional and essentially reimpose the sentence that had been imposed on Roger Stone.
Okay, so in other words, if she takes no action here, this thing is essentially done and over, but she could jump in and at least try to take some sort of action, and which I guess is what you're arguing for. So what is the constitutional and legal basis for your argument, as laid out by Jed Sugarman and Ethan Lieb, that free speech for people believes should at least be considered by Judge Jackson in this case?
Sure. So let me start, Brad, with where you left off kind of in that last question, with the suggestion that the power of pardoning of the president is absolute, because that's a common misperception, both in the public at large and frankly in the legal community, and you often heard that said. And I think in your comments earlier, when you referred to the president's considerable Article 2 powers, that's actually a more accurate summation of that power than the word absolute. The notion that the presidential pardon power or any other presidential power is absolute is just flat out wrong and foreign, really, to the Constitution and to our whole system. We don't live in an absolute monarchy, at least we're not supposed to. We're supposed to be living in a constitutional democracy. This is the whole reason the founders fought a revolution and adopted a constitution, was to overthrow even the watered-down absolute monarchy of the British Crown and to ensure that we instead had a democracy and a government, including the president, of limited and constitutionally constrained powers. So the Constitution bestows certain powers on Congress and certain powers on the president, but as the Supreme Court has recognized, all those powers, including the pardon power, are subject to the textual constraints in the Constitution itself. So this is why, to take one example, if the president were to issue a full pardon to, say, all white police officers who've injured or killed any black person, these pardons would not be valid. They would be blatantly unconstitutional, in violation of equal protection of the laws and other provisions of the Bill of Rights. To take a different example, suppose the president were to engage in a direct financial bribe, agreeing to issue a full pardon to Bernie Madoff in exchange for a $5 million payment to Ivanka Trump and Jared Kushner. Most people would acknowledge that this pardon cannot be constitutionally valid.
Well, most people who aren't Trump supporters, but okay, press on. I take your point.
Okay, so then the question is, well, what provision of the Constitution does that violate? Well, as you alluded to in describing our motion, in the very clause establishing the presidency itself, Article 2 of the Constitution, the framers included language making clear that the presidency is in effect a public trust. Its powers must be exercised for the benefit of the public and not the personal benefit of the president. They specifically provided that the president is required to take care that the laws be faithfully exercised and executed, and they required the president to take an oath to faithfully execute the office of president. Now, granting a pardon or a commutation for a completely unlawful and illicit purpose is antithetical to this obligation to ensure that the laws are faithfully executed. So where does that leave the Stone pardon? And you essentially captured the answer in your initial remarks, Brad, but to elaborate a little bit, there's ample public evidence that this was part of an illicit bribe. Stone agreed to protect the president by refusing to tell the truth, even lying to investigators investigating the role of Trump in his campaign in Russia's unlawful interference in the 2016 election. And Trump agreed in exchange to protect Stone from the legal consequences of his conduct. But even if you don't characterize it as a bribe, at a minimum, the public evidence, including statements from Trump himself throughout these last several years, and from the White House in describing the reasons for this commutation, that evidence demonstrates that Trump's purpose in commuting Stone's sentence is to reward him for covering up for Trump and to continue to protect Trump. So this is not faithful execution of the laws as required by Article 2. This is obstruction of the law, it's obstruction of justice, and it's obstruction of lawful investigations, all for corrupt and self-interested purposes. And so if there is to be any remedy for that, and any remedy to Roger Stone's situation, it's up to the court in this particular case to scrutinize the commutation. And if the judge agrees that the evidence that I've outlined briefly here is persuasive, to declare it constitutionally invalid, and to order Roger Stone back to prison.
And in fact, Roger Stone himself, I think, in the days following his commutation, said something along the lines of, they wanted me to talk. I didn't. Had I done so, it would have been much worse for the president, or something along those lines. He seemed to be admitting that he was, in fact, covering up for some crimes or another of the president. And so that is, as you seem to describe it, the corrupt purpose that is not unlike an actual financial bribe, a deal between the two of them. Has a grant of clemency by president, whether a pardon or a commutation, ever been blocked or overturned in the history of our country?
Not that I'm aware of, Brad. On the other hand, we have never in the history of the country had a grant of commutation like this, in which the president has granted a commutation to someone who has publicly acknowledged covering up for the president in order to protect the president, and under circumstances in which there has been a public exchange between the president and the defendant about the purposes, the corrupt purposes for the commutation. So no, we've not had a pardon declared invalid and unenforceable by a judge, but we have never had a pardon like this that has been so demonstrably corrupt.
and never a president like this that has been so demonstrably corrupt. Of course, I hope that this effort obviously is successful, but to be frank, even if Judge Jackson here approves your motion, Ben, and if she concurs with you that the grant of clemency was improper or corrupt, I know it's down the road a bit, but do you feel that this particular stolen U.S. Supreme Court would ultimately concur, even if you are right on the law and Jackson finds as much? I mean, this is a Supreme Court that was willing, for example, to issue a 5-4 ruling literally in the dead of night a few days ago, to let the federal government execute a man in what appears to be in violation of their previous death penalty related opinions. I'm not sure that this court is actually all that interested in facts and the law and the Constitution.
Well, certainly that case gives one cause to doubt whether it is. On the other hand, a number of recent decisions suggest that there are at least certain members of the conservative majority willing to join the more traditionally law-abiding minority of the court in upholding the court's institutional reputation. And, this like the cases recently in which the court effectively said, no, Donald Trump is not immune from the laws, and he must comply with lawful subpoenas, and he can't protect his tax returns from being turned over in a criminal investigation, that they have shown a willingness to recognize that it's not their job to be Donald Trump's protectors, and that they do need to fill the role of holding him accountable. And I think that there are members of the court that will recognize that if this kind of commutation is allowed to stand, they really will be setting a precedent that, in fact, it is an absolute power. And so the next time, hopefully it never happens again, but if we ever again have a president as corrupt as this, people can line up, to have their payments made and get their pardon.
Yeah.
$1 million per defendant, and they get a pardon. And the president collects the $1 million from each one and issues pardons, and the court says, sorry, there's nothing we can do about it. We've said this power is absolute. I don't think we want to go down that road, and I think that there's enough justices that recognize that, or will recognize that if this court gets to that, if this case gets to them, that they may well agree that this is an invalid commutation and that it cannot stand.
Boy, I hope you're right, Ben. And I have a question or two about that long line of people who may be lining up for those pardons in a second. But when do you expect a ruling then on your motion here from Judge Jackson? And again, this is just to get the permission to essentially submit your argument, your brief. So if she accepts this amicus brief, when would that be? When would that happen? And then if she does accept it, what would happen next at that point once she considers your brief?
Well, the shorter answer is we don't know, because there's not a particular process or timeline under the court's rules or practices for this. This is obviously an unusual circumstance, but I would expect that we would get an answer reasonably soon as to whether the court will entertain our amicus brief, and I would anticipate that if the court does decide to grant permission to file it, that we probably would be given a fairly short period of time to turn it around and get it submitted to the court. And I would anticipate, again, it's all up to the judge what the judge decides to do, but I would expect that if the court did allow us to file the brief, that the court would then provide an opportunity for the parties, both the lawyers for Mr. Stone and the lawyers for the Justice Department, to submit their own briefs. And I would hope that if the court did all those things, that it would further offer an opportunity for additional interested parties to weigh in on this issue. And then perhaps the court would make its decision based on all of those written filings, or it's possible the court would decide that it wanted to take evidence, additional evidence. The public record is already quite substantial on what the purposes of this commutation were, but the court might decide to take additional evidence by way of a hearing, and then would make a decision as to whether or not that this commutation should be declared invalid.
Absolutely fascinating motion, Ben, and turn of events, I guess I should say. And I guess some of this depends on how successful this effort is. But without it being successful, without it changing where we seem to be heading, it seems that we can, sort of see the writing on the wall here. Trump has already pardoned or granted clemency to his friends and campaign supporters like Sheriff Joe Arpaio, now Roger Stone. Do you have any doubt that similar clemency will soon come for his former National Security Advisor Michael Flynn, who also lied to federal investigators about his conversations with Russian officials and concealed that he was a paid foreign agent of Turkey, and even Paul Manafort, who did much of the same? Do you have any doubt that those are coming? First part of that question, I'll let you answer.
No, I don't, Brad. I have no doubt. In fact, in the case of Michael Flynn, it's already here. The president is trying to shortcut through his, I forget the description you used of the Attorney General, but it was an apt one.
Fixer, his fixer.
His fixer,
I think,
yes. He's already got his fixer on that case, and his fixer, Attorney General Barr, has essentially ordered his subordinates in the Justice Department to drop the case against Michael Flynn, and that issue continues to be litigated, as I believe the current status is that the district court judge has asked for the full Court of Appeals to review the decision of a panel of the Court of Appeals that had ordered him to go ahead and grant the dismissal.
Right.
So if that decision of the Court of Appeals stands, Trump may be spared the need to pardon Michael Flynn. But if it goes the other way, and ultimately the case against Michael Flynn is not dropped, then I fully expect, as you suggest, that Trump would seek to pardon Flynn, and he may well seek, as you suggest, to pardon or commute the sentence of Manafort. I think one of his co-conspirators that is not likely to be getting a pardon or a commutation is Michael Cohen.
Right.
And the reasons for that differential treatment are quite obvious.
Yeah. Well, and actually, I think that in one sense supports your case here. I mean, here was a guy who conspired with Donald Trump in many of these same efforts before he was elected president. And in Michael Cohen's case, he did sing on what he knew about Donald Trump, and he was allowed to go to jail Roger Stone didn't sing about what he knew, and he was granted this favor of clemency by the President of the United States. Ben, I've got just a minute or two here, but with all of this in mind, and Trump's obvious interest in wanting to pardon people who might protect him, the larger question, it seems to me, before leaving office, whenever that might be, do you suspect that he would also use that power, that considerable power, to grant preemptive pardons to many other friends and close officials, and particularly I'm thinking of his family members, and yes, himself? And if he does, would any of that be legal and or constitutional?
And that would turn on many of the same issues that we're seeking to raise here in Roger Stone's case, for the same reasons that we believe the commutation of Stone's sentence is unconstitutional. Those pardons that you're anticipating would likely be unconstitutional as well. But yeah, I think the broader point perhaps you're making, Brad, is whatever happens to our motion here, this issue's not going away. This is an issue that's going to loom large over the remainder of this presidency.
Yeah, and I think that's another reason why this case is important, no matter how it comes out, at least to have this argument in place before he starts his pardons for himself in his own self-interest for his own corrupt purpose. Ben, I'm short on time here, so we didn't even get to discuss some questions I had about your book. Maybe we'll do that down the line in the future. You are the co-author with our friend John Bonifaz and Ron Fine of the book The Constitution Demands It, The Case for the Impeachment of Donald Trump. I think there still may be an argument in the not-too-distant future to impeach him again and or impeach, yes, his fixer, Bill Barr, but we're going to have to save that for another time. I hope you'll stay in touch with us as this moves forward. It's a fascinating case, a fascinating turn of events. There's so much else going on. I think few have noticed it, but I suspect they will notice it, particularly if Judge Amy Berman Jackson grants your motion to allow this brief to move forward. Ben Clements, he's the board chair and senior legal advisor at Free Speech for People. You can find their important work at freespeechforpeople.org, and you can follow them on the Twitters at FSFP. Ben Clements, really appreciate you joining us today on the Bradcast, sir.
Thank you, Brad. Great to be with you.
Thank you, Counselor. All right, we'll take a quick break. And I got to tell you, by the way, Free Speech for People, that was set up by our friend John Bonifaz. Great organization.
Yes.
Could really use your support, other than for, not just on cases like this, but they're doing some crucial work on elections, election integrity.
And election security,
Yep.
and election laws.
Yep.
It's very encouraging that there are people out there who are still fighting, who are not giving up.
We don't, recommend a lot of organizations out there. I know there's a lot of organizations that, fight for Democrats and whatever. But folks who really stand up for, A, progressives, but B, the Constitution and the progressive fight for it are rare indeed, and they are not necessarily well supported out there. So freespeechforpeople.org. Which came together, by the way, to create a new amendment to overturn Citizens United, and they're still on that job as well.